Hello everybody, my name is Assaf Cohen, and today I'll talk to you about the importance of a founder's agreement in a startup. Well, first of all, a short introduction about myself. My name is Assaf Cohen. I'm a high-tech lawyer in Israel, specializing in startups. My main field of practice is legal consulting to startups, from really growing together with a startup from the pre-seed idea stage to round of investments, IPOs, deemed liquidations, aka exit events, really with the startup all together. I'm also a business arbitrator in startups that I'm giving them legal advice. Now, a lawyer is a very important service provider for each startup that has many legal challenges, contracts, legal opinions regarding the startup's activity, terms of use and privacy policy. And in addition, with the lawyer's experience with startups, he can also help the startup progress and uses connections with investors and other service providers that could really help your startup. Now, we'll start first of all with a short explanation about what is exactly a founder's agreement. So literally, as it sounds, a founder's agreement is a contract signed by founders of a startup which settles the main issues in each startup and sets the terms of its activity. Actually, the founders agreement is laying the foundations for the future company's activity and the articles of association of the company. Now, every startup begins with one small step, from some people working from their bed at home or a garage to a really gigantic corporation. Apple as well started with Steve Jobs working from his garage to really something gigantic and enormous. So the first thing you should do is to sign a founders agreement. And now we'll talk about when to sign a founders agreement. So ideally, of course, it's as soon as possible. But practically, you go for a founders agreement when you're in a more advanced stage before the MVP. That is, in short, a minimum viable product. So it's enough to release the app. Let's say you're developing an app. It's enough to release it to Apple's App Store or Google Play Store. It doesn't necessarily have all the features you wanted it to have, but it's enough to release it to the public to satisfy your potential clients and customers and users. So, as I said before, when you're in an advanced stage before the release of the MVP, and you understand that it's not just some side hobby with your friends, but it's rather something that's developing to something that is serious. Now, regarding when to register a company, it's a question that I hear a lot. Now, when should you establish the company and register it? In Israel, practically startups sign a founders agreement before the registration of a company. And obviously, you also need to do it because, for example, in order to decide how many shares each one will receive, you first need to do the founders agreement, and only then you can register the company. So usually it's also before the first incomes or following a significant investment. And that stage, before you establish the company and register it, you need to sign a founders agreement. Now, there's also an important question that I'm being asked a lot. Why should I sign a founders agreement? We're good friends, we know each other, we don't need an agreement that will settle our relationships. We already know each other. Now, beyond the legal reasons that I'll discuss thoroughly later, before signing a founders agreement, and I realize it with my clients, it feels like some hobby, some experiment, something that they still don't know if it'll be something that will really develop. But after signing a founders agreement, I see that my clients are a lot more committed. They're taking it a lot more seriously. They understand that it may potentially become a business rather than some idea. And as I said, from my experience, there is some psychological effect. You're a lot more organized, connected. You start recruiting clients and attracting customers. Startups that were before the agreement progressing a bit slow, they're afterwards progressing significantly faster. And in addition, it's also very important for the investors to see an organized startup. Everyone knows what they're doing, when are they doing, and how they are doing. So Today we'll start our own startup with our founders, but we'll talk about it soon. And we'll see what happens when you have a founders agreement and what happens if you don't have a founders agreement. So a founders agreement, as we said, it'll help you be organized. It'll set the terms and conditions of the operation and management of a startup, set the relationships between the founders. And as you'll see, when you don't have a founders agreement, there is a lot of disorder, there's a lack of certainty, and it really may harm you. So let's start our startup. Let's say that we have 4 guys working on a startup. We'll call them Amy, Betty, Chris, and David. 4 founders want to establish something together. It's something serious. And first of all, they need to agree about the contribution and roles and services of each of the founders. So let's say that they agree the following. Let's say that they agree that Amy will be the CEO. She's in charge of the management. They agree about that because Amy is more experienced in roles of management. Maybe it's a second or third startup. She really knows what to do and how to manage things. Betty will be the CTO. She's in charge of the technology. She's a programmer in some big firm. She already knows how to do things and how to lead in all matters regarding the programming. Now, the third founder is Chris. They agree that he'll be the CFO. He's in charge of financial matters, for example, everything that's related to budgets, maybe signatory rights in the bank. And the fourth founder is David. He'll be the CMO. He's in charge of the marketing, an experienced salesman. He has many connections and he can easily reach potential clients and customers. Now, you can be not specific. You can just say Amy the CEO, Betty the CTO, Chris is the CFO, and David is the CMO. You can also be more specific maybe. For example, you're saying, as I said, that Chris will be in charge of the signatory rights. Amy will have all the decisions regarding investments and assets. You can decide that, or you can decide not to be so specific. Now, if you have an agreement, things are very organized, the roles are very clear, each one knows what he's doing, what's his contribution. You don't start quarreling if you're doing your job and you're not doing your job appropriately. Things, as I said, are very clear and certain. These are 2 things that are very important in each business, particularly in a young startup. If you don't have an agreement, things also are not organized, roles are unclear, you start quarreling and it doesn't do any good for the startup. Well, the second thing that they need to decide on is how many shares each of the founders will be entitled to. Now, let's say in our startup, Amy, Betty, Chris, and David agree to have equal shares, 25% each. Now, you can decide that, or you can decide, for example, to give one of the founders more shares. It can be, for example, maybe Chris, that he brings more money from home. He brings a large investment by himself. For example, he brings $50,000. So you understand and agree that it's very legitimate and reasonable to grant him more shares than the other founders. This is just an example. You can decide as ever you want and as ever you wish. It's totally up to you. Now, the shares are the main assets in the startup. It's worth money, obviously. Today, the startup at first is worth nothing, $0, but after many years, it may be worth millions of dollars, maybe billions of dollars. So it's actually one very critical decision to make. So if you agree on it on the first stage, it's very simple to go on with this. But on the other hand, if you don't agree with it and you just delay that decision, things are a lot more complicated. It's a lot more difficult to reach that decision, especially when this involves money that, as I'll speak about it soon, it's a very sensitive issue. Now, another very important thing, maybe the most important thing to agree on, is how you make decisions in the startups. Well, there are many critical decisions in each startup. Maybe things regarding the business plan, the budget, your investors, loans, contracts, assets, signatory right in the bank, maybe a material change of the business plan, hiring staff and other service providers, many important decisions to make. Now, let's say that our founders decide to reach decisions with a majority vote. they vote regarding the business plan, 3 against 1, and they're good to go. But what happens if you have a tie? How do you reach decisions? This is something that many founders don't think about. They think at first stage that everything is okay, but later when they can't reach a decision, things turn out really bad. So let's have a case study to demonstrate the importance of deciding about how to make decisions. Let's say that our founders, Amy, Betty, Chris, and David, they meet an angel investor and they pitch in front of him, they show him their idea, they show him the team, their exact stage, and let's say that our investor, we'll call him Jack, is very impressed and he wants to invest in the startup, and he gives them 2 investment offers. Well, usually there are 2 types of investment in general. There's a cash investment that the investor just transfers cash to some bank account to give him, and there's also a convertible loan. Well, in short, the convertible loan is basically a loan which you have to pay back with an interest rate, but the investor has also the option to convert the investment amount to shares. Let's say that Jack, our angel investor, offers the company to purchase 20% of the company's share in return for $200,000, but he also offers them a convertible loan that he'll bring them $200,000 and they have to pay him back with an interest rate, but he can also convert the investment amount to shares at a later stage, let's say after 5 years. This is good for the investor many times because today the company is worth, let's say, $1 million, meaning that for 20% of the shares he needs to pay only $200,000. But in 5 years' time, the company will be worth $50 million, and then he can convert his investment amount to shares when he purchased 20% of the shares only in return for $200,000. That is a very low price per share. Now, our founders need to reach a decision whether to go for the cash investment or the convertible loan. Now, let's say after having a meeting, Amy and Betty prefer the cash investment, but Chris and David prefer the convertible loan. They think it's better. Now, this is what we call a deadlock. Even after the founders try to convince each other and they press each other to go for maybe the cash investment or maybe the convertible loan, they can't convince each other. Now, Jack, our investor, he's telling them, okay, you have 30 days to decide. I won't wait forever. But what may happen in case of such deadlock is they won't be able to get to a decision. Things may collapse very quickly. They can argue and quarrel, and the startup will collapse because Amy and Betty will say, okay, we're out of this business. We don't want this. And Chris and David will also say, okay, we quit. We're starting our own startup. The investor, Jack, obviously, he doesn't like it. It seems unprofessional and not good. And he's just saying, okay, goodbye, fellows. I wish to invest in the 4 of you as a group, not just in 2 of you. And now I see you quarreling. This is not professional. If today you're quarreling, what will be in the later stage? So he just takes back his offer and the startup ends with nothing, usually collapses after such event. So obviously, if you don't have agreement, these kind of events happen a lot, very occasionally. So this is obviously not a good thing. But what is very good? It's good to have an agreement that solves a deadlock, some mechanism that decides what do we do in case of a tie. Now, there are many methods to solve such deadlock. What I usually advise my clients, sometimes it will be forwarding the dispute to some external arbitrator or consultant. It can be someone you trust who's very experienced with startups. And you go to that consultant and you tell him, okay, we're not able to make a decision about the investment, cash or convertible loan. You decide, please. And he'll look at it, he'll hear all the sides, and he'll say, for example, okay, based on the company's current situation and the things that I've heard, I think the best thing is to go for the cash investment. And the founders will respect his decision. They'll go to Jack, the investor. They'll tell him, okay, you went to the cash investment and everything is good to go. The startup receives money and starts growing rapidly. That's great. Another thing that you can decide, for example, is giving an extra vote to one of the founders. Let's say, for example, that Amy is very experienced as a CEO. She already was a CEO in other startups, and you trust her. So let's say the other founders say, okay, in case of a tie, Amy will have an extra vote. She will decide what is up to her and will respect the decision. And that way, the startup is good to go. As I said, without any founders agreement, we cannot solve the deadlock. You start arguing, things will really become ugly, and your startup will collapse. Now, you can also forward the dispute to any other dispute to an arbitrator or consultant. Doesn't mean necessarily about decisions. It means maybe one of the founders doesn't contribute good, so you want to forward the investor to the arbitration. So in arbitration, it will be decided what to do with them. You can also decide that several material issues will require a unanimous vote. For example, a liquidation of a startup, meaning closing it, or selling the patents of the startup. These are very material decisions to make, and many times it's best to agree that such issues will be resolved only upon a unanimous vote. There are obviously many other methods to solve deadlocks. It's all up to you. To every startup, I advise something else according to the founders and the stage and the experience. It depends on many things. Now, another very, very important issue is the intellectual property and confidentiality clauses. Well, this thing is super critical for your investors. Any reasonable investor will require you to represent and warrant that you fully own the IP, that no third party is entitled to all or some of the IP rights, royalties, or ownership rights. I'll give you an example. Back in time, I represented the colleges in Israel, all the startups in the colleges in Israel. And if a student developed something in the college's lab, using the equipment of the college, basically the IP fully belongs to the college from that moment. And that practically means that the startup has nothing. It doesn't have his IP assets because it belongs to the college. You must also check your work contract. Many workplaces, they set in the contract that anything that you develop, whether it's in the workplace or at your own free time, belongs to the workplace. You need to check it very carefully because your IP is your main asset of each startup. Without the IP, the startup usually is worth nothing. And as I said, it's very, very important to represent and warn that in front of your investors. You don't want one clear day to receive a letter from an attorney claiming that his client owns the IP. It's very unpleasant to hear of such thing, and these things happen. It's not some theoretical situation. So basically, you need to agree that all IP rights belongs to the startup and later will be assigned to the company upon registration. As I said, very important for future investors. And of course, you need to agree that all information of the startup is confidential and may strictly not be disclosed to any other third party. Now, information is not necessarily just the patents, it's also client lists, flowcharts, prices, technical information, different statistics that you gather that can really harm your startup if a third party will be exposed to. Now, if you have an agreement, these things are very clear. You can easily show your investors, okay, we fully own the IP, no third party has any rights, not to ownership, not to royalties. The IP is fully owned by us and your investor will be pleased. However, without any agreement, this can be uncertain. And for example, a founder that is not pleased may leave the startup. He may own some of the IP or maybe demand rights in the IP, develop something of his own, and you really have a serious problem here. Now, another very critical thing to agree on is non-compete and non-solicitation. Well, it's very important for the founders to understand that during their work in the startup and for an agreed period later, you must not compete with the other founders or the startup. not as an employee, a shareholder, a founder, or a consultant, and of course, not to solicit current clients for your own startup. This is very important. Obviously, the founders are exposed to very sensitive knowledge. They can't just leave the startup and open something of their own. They need to fully commit not to do it. Now, if you have an agreement, of course, it's enforceable in court. You can sue that founder and receive damages and compensation, obviously. But if you don't have an agreement, each of the founders may just start his own startup, leave you, join maybe another startup using very sensitive inside information. So therefore, it's very critical. Obviously, to your investors, it's also very important to know that the founders are fully committed. No one will just jump off the ship and start his own thing. Now, another very important thing to agree on is the financial matters. Now, money issues can be obviously very sensitive. We don't like talking about it, especially with friends, with founders, but a startup has many expenses, even small expenses like paying for servers, maybe purchasing equipment like laptops, maybe rent if you're in some space working, and you need to decide who will fund the startup's activity and how. You can agree, for example, that each of you will take a small loan, maybe on $5,000, $10,000 for the startup to contribute. You can maybe agree that each of you will bring money from home for the startup. It's possible, it's up to you. And another very important issue is decisions regarding dividends, salaries, and other benefits. Well, practically a startup at the first stage does not have many incomes, doesn't have incomes at all. It's totally broke, what we call. So financially, it's not able to bring you dividends and salaries. But I've seen cases that after a first investment of $200,000, $300,000, the founders just agreed to have dividends and salaries, and the startup just collapsed because it ran out of money. All the money was burned down. So it's usually very important to agree that you'll receive salaries or dividends or other benefits only upon financial ability of the startup. This is usually decided by maybe the CFO, but it can also be your accountant will decide that someone that is external, that has no personal interest. This is, of course, very, very important. Now, as I said, and like other issues, if you have an agreement, you're good to go. Things are very simple. But if you don't have an agreement, you may start quarreling with each other. You'll argue about money. Things can end very, very bad. Now, another very important issue is blocking period and first refusal. Now, let's say it this way. You know each other. Amy knows who is Betty, and Betty knows who is Amy, and Chris and David, they all know each other. They trust each other. They rely on each other. They know what they're capable of. You don't want someone in your company without you knowing or without you agreeing to it. So usually what's good to agree on is some blocking period that during the current stage and for a certain period, it can be, usually it's a few years, none of the founders is entitled to sell or transfer their shares in the company to any third party without having the prior written consent of all the founders. For example, if Chris has a sister named Mary, he can't just give her half of his shares without the other founders agreeing. It doesn't look good, not in the cap table, not to your investors. It's really not recommended, not good. Your investors won't like it. These things may ruin a startup. So let's say that we set the blocking period for 2 or 3 years. That's usually what I recommend my clients. Some they ask for 5 years, one even asked for 10 years. That's a bit irregular, but that's what he wanted. So, okay, he was good to go. So after a blocking period, still the founder can just transfer his shares to anyone that he wishes. He still needs to go through a process. Now, what is that process? That's exactly what we call the first refusal. What is a first refusal? The first refusal is actually a procedure that after the blocking period expired, let's say that we set the blocking period for 3 years, and now Chris wants to sell half of his shares to an investor that he found. his shares are now worth a lot. 12.5% of the company are worth $2 million, and he wants to sell it to someone. He can't just give it to anyone. Or for example, he can't just give Mary, his sister, some of the shares for free that she'll have many benefits and dividends. First of all, he needs to give a written notice to the other founders mentioning the price, the terms, and the identity of the investor, and the other shareholders have the first and exclusive option to purchase these offered shares at the same price and terms. For example, Chris must approach the other founders, tell, dear Amy, Betty, and David, I have an offer at the moment of $2 million for half of my shares. You can compare the offer, you can give me the same offer, or you can just let me to sell. So each of them, for example, if Amy wants to purchase his shares, she can write a $2 million check, hand it over to Chris, and Chris will be forced to transfer her his shares that he wanted to offer to the investor. But usually after an agreed period, it's usually 30 days, it's quite enough to think about that offer. If none of the founders wish to purchase these shares at the same price, so Chris is free and is allowed to offer these shares at the exact price. For example, Chris can't just do something that is not acceptable. Obviously, he can't just offer his shares for $2 million to the other founders and give it for free to Mary. Obviously, it's not something that he can do. Now, if you have an agreement, that procedure is very clear. No one can just give his shares to anyone else at any price that he wants. He needs to offer these shares to the other founders. But if you don't have an agreement, so each of the founders can just give his shares to anyone that he wants, anyone that she wants, and there's nothing you can do about it. It looks horrible on the cap table. Investors don't like that, and it's very bad for the company, obviously. Now, many people ask me when they come to my office to sign a founders agreement, for telling me something that's very reasonable. They tell me, for example, let's take our founders. And they tell me, okay, Assaf, we're now good to go. We like each other. Everything is okay. But what happens if one of us will not do his job correctly? What if one of us will set criminal charges? What do we do? Is there a way to just take someone's shares? Now, I don't know what's the situation in other countries. I guess it's quite similar, like the situation in Israel. So according to the Israeli law, you can't just take someone's shares. Shares are assets, just like your car or your apartment or your cell phone or your laptop. I can't just take them. If I want to take someone's shares, and it doesn't matter what he did, I need a court order. I need to sue him in court. It's a procedure that could be very long. It could be very expensive, and also need a good reason. I can't go to court and ask Amy can't just go to court and say, I want to take Betty's shares because Betty doesn't come to our weekly meetings. That's not a good enough reason. So it's very problematic that someone has shares and he doesn't do what he's supposed to do. You can't just take him. But there still is a solution. There is something that you can do. It's called a repurchase agreement. It's signed together with a founders agreement. I always recommend it to my client. They usually listen to me and it's very good for them. Now, what is a repurchase? A repurchase agreement is an agreement stating that if a founder fails to provide and achieve his services, so the company has an automatic right to repurchase his shares, and it's usually done in a symbolic price of 1 cent per shares. Let's say, for example, Amy holds currently 2,500 shares. The company can just buy it for $25. Very simple, without her able to do anything. Now, it's very simple. When they come to my office to sign the founders agreement, they sign transfer deeds. I take it as a trustee, and I transfer the shares back to the company only in case of some extreme event. Usually it's activated, the repurchase agreement, it's activated when there are serious problems with the founder. For example, he's not contributing, he doesn't come to the meetings, he doesn't come at all, he doesn't answer their calls, ignores them totally. There can also be other things. for example, embezzlement, criminal charges, inappropriate behavior, when they really don't get along with the founders. Now, I always tell them, you don't need to worry. It's not that you're always under some magnifying glass and we're looking at you and we can at every moment just take your shares away. It's not like that. It's insurance. It's in extreme cases that one of the founders, I don't know, really severely ignores you and doesn't come, and he's been charging criminal charges, something very extreme that obviously your investor won't like to see. A problematic character with 20% of the shares not doing anything. It looks good, and the investor will usually tell himself, I don't want this company, I don't want this startup. It's a very, very bad thing to do, and you won't invest in you. Now, as I said, if you don't have such agreement, it's practically impossible to take a founder's shares. It's very problematic. But if you have such agreement, again, it's not something intimidating. It's not really suspicious. Just in certain events, you can take its shares. Usually, such clause is activated after a board decision or after some external arbitrator or consultant will decide to do that. Now, people always ask me, there's something else as a repurchase, there's vesting. Now, what is vesting? Vesting is sort of the opposite of repurchase. If in repurchase, each of our founders, Amy, Betty, Chris, and David, receive 25% of the shares upon the registration of the company, well, vesting is kind of the opposite, because at first the shares are held by a trustee. Let's say it's usually a lawyer, and following an agreed period, the shares are transferred from the trustee to the founder. For example, you can decide in each successful year of contributing, half of the shares will be transferred from the lawyer, which is a trustee, to the founders. Let's say, for example, if Chris didn't succeed in that year, he wasn't good, he wasn't behaving appropriately, maybe charged with criminal charges, was very a problematic character, so Chris will not receive his shares. Now, many founders ask me if it's good to include it in the founders agreement. Now, my personal opinion is that it's not good for a founders agreement. It may be good for advisory board members, may be good with certain service providers. I think that it's not suitable for three main reasons. Well, the first reason, there's a psychological reason. The atmosphere is very tense. The founders always feel like they're in some kind of competition. They may interrupt each other because eventually Amy thinks, okay, if Betty will not be able to do her job, so actually the 12.5% that she won't receive, I'll receive them on her expense, and therefore it's better to just kick Betty out so I'll have more shares. So the founders are always in some kind of competition. The atmosphere is very bad. This thing is not good for a startup. The startup has to start with full trust between the founders. They have to fully trust each other to get along together. And if they're suspicious of each other with such vesting method, personally, I think that it's really bad. Another reason, there are some tax implications on vesting that repurchase doesn't have. These are things to further discuss with your accountant or tax advisor. You better consult him. I know that in Israel it may be problematic regarding tax issues rather than the repurchase, but in each country it differs. You need to check it, as I said, with your accountant. And another reason is the legal reason. Vesting is a lot more complex procedure. You need to appoint a trustee, you need some transferring procedure, but more than that, it's very difficult to define a successful contribution. How do you do that exactly? It's very, very difficult. For example, what do you decide that, including hours that you contribute, maybe some goals that you set? It's very problematic because if you say, for example, 20 hours of work and you will have vested shares, it's not very good because 20 hours of one founder may be worth a lot less than 5 hours of another founder. So this is not really practical in my opinion. and therefore a repurchase may be a lot more suitable. The founders trust each other, it's a lot better and a lot more well. I think it's more healthy for the company eventually. Now, another main question that I received, obviously, there are many other fatal decisions to reach when you have a founders agreement, a lot more issues that are very important to reach. And many of my clients ask me, do I need a lawyer for all this? Now, I'm telling them something like this. A lawyer needs to know not how to write, but what to write. If a group of founders will come to my office and tell me, okay, Assaf, we want A, B, C, D, F, G, all these clauses, I'm just telling them, honestly, you don't need me. You can draft a founders agreement by yourself. You don't need me. But you do need a lawyer especially if you don't have much experience in startup fields. A lawyer will know not only how to write, but also what to write and what to advise to each of the startups. And I'm telling you, every startup is different from the other. It's never the same founders agreement. It's not that I have some template that you come to my office, I just change the names and give you an agreement. It's a lot more complicated than that. It's one of the most important contracts of each startup, if not the most important. There are many issues to settle, and in addition, it's just like any other professional, whether it's your pipeline or your car that is not working well and broken. If you're not 100% sure, it's better not to try fixing your pipeline or car on your own. You better call the plumber or the mechanic, because by trying fixing it without having the appropriate knowledge, you may do a lot more damage, and fixing that damage rather than precautions and going to a professional in advance is a lot more expensive, obviously. And in addition, a good lawyer is very critical for your startup. He will be able to guide you. An organized startup is a good startup. Investors like that startup. The founders are happy. They trust each other thanks to a very good agreement. And as I said, our founders, Amy, Betty, Chris, and David, will contribute to the startup. They'll be happy. Each of them will know what to do, what he's in charge of, what they should do in specific decisions, and when they have a deadlock. It's very, very important. And as I said, if you don't have agreement, you're not organized at all, the roles are unclear, and there are many cases of founders arriving at court because they were fighting about a startup, they didn't know what to do, and the splendid idea, splendid group of founders just collapsed because they didn't know what to do. There was some dispute and they were just unable to solve it. Now, other things that you obviously need to do with a founders agreement, obviously there's also the corporate organs of the startup. We'll not discuss it in a thorough way today because in each country it's a bit different. You have the general meeting having some decisions regarding technical issues, especially maybe special mergers and acquisitions, and you have the board. That's the main part in the startup, the managing body. The board is managing the company, has all sorts of powers and authorities. For example, approving the company's budget, examining the financial state of the company, responsible for the preparation of the company's financial reports, appointing and dismissing the general manager of the company, giving its opinion regarding special acquisition offers, deciding on distribution of dividends. Our founders at the moment, as we said, Amy, Betty, Chris, and David, 4 of them are at the board, and it's possible to also decide that only one of the founders will be in the board or 2 of the founders. Some of my clients come to me and I see that maybe one of them is more organized, more experienced, and I recommend my clients, listen, for example, Amy, she's a CEO, she's very experienced, it's her 3rd startup, she knows what to do. I think, in my opinion, that's what I advise you. My advice is to let her be the only director. It's a lot more clear that way. There is no decision-making problems. She meets the investor, obviously with the rest of the team, but the investor knows, okay, Amy is in charge. If I have a problem, I just go to Amy, I talk to her, she solves it, and things are very, very clear and obvious. So again, sometimes this is appropriate, sometimes this is appropriate. My advice, if there's one that is very experienced and good, just let him control and manage the company. The board, by the way, it doesn't mean that you get more money. Usually, obviously, a startup at first doesn't receive any salary. They're practically broke. It's not that whoever is in the board is looking up at people. It's not that way. And other decisions, obviously, is that the board appoints and removes and suspends managers, officers, clerks, attorneys, agents, accountants, and other employees. And as I said, there are many, many decisions to make in a startup. You have to be very organized. Now, I'll talk about another thing, another decision method that usually I don't recommend it, but some of our startups like it. It's the buy me, buy you, the BMBY. In Israel, it's called sometimes Bambi. So what is a buy me, buy you? Now, it's a deadlock resolution saying practically this thing. If, for example, Amy, Betty, Chris, and David need to reach a decision whether to invest in the company, in a cash investment or convertible loan, as we said before, they can decide maybe to forward it to a consultant or arbitrator. They can maybe decide to give an extra vote. They can also decide in cases of dispute, for example, a deadlock, each of them can buy the other founder's shares. For example, it's really like a Tinder that everyone writes on a piece of paper his valuation of the startup. He wants to buy the other one's shares. For example, Amy says, okay, I'm now calling a buy me, buy you process. Let's each of us on a piece of paper the valuation of the startup. How much is he willing to give for purchasing the other founder's shares? You write it on a piece of paper, and whoever is the highest bidder wins practically the other founders' shares. And obviously there's a minimum value that you need to set. You can't buy the startup for $20, of course. So you need some minimum valuation. Usually I recommend several hundreds, thousands of dollars. In a more advanced stage, it may be millions. I don't recommend this for a startup just in a foundation. I think it's a very radical solution. Not really suitable for some guys that are currently just working from home from their bed. I think it may be suitable for more experienced startup guys. Not at this stage. I don't really recommend it. Well, I have some clients that really requested that. If they're asking me to, so I'm going with them. I'm not quarreling. But again, in my opinion, I don't really think that it's suitable. Up to you. Well, other small things and decisions to make. What happens in the event of the bankruptcy or death of the founder? This is also very important to agree on, though it may be sensitive. Well, obviously, if one of the founders goes bankrupt, it's very important to settle that. He will be forced to transfer his shares to the other founders on ways of repurchase. It's usually done, so it will be very fast. Another thing is the death of the founder. We don't really like thinking about it, especially when we're young and pretty. But it's something that we need to think about. So you can decide, for example, that if a person is entitled to a share because of a death of one of the founders, you can decide, for example, that you'll be forced to transfer it to the other founders free of charge. You can decide, for example, that one of your descendants will also receive the shares and will enjoy the dividends. It's totally up to you. Now, I'm just telling you this. Don't tell yourself, it won't happen to me. We're okay. We're friends now. We don't need an agreement. We're just shaking hands and that's enough. I'm telling you, this is not enough. Many cases reach court because some founders say, okay, it'll be fine, don't worry, we like each other today. And I'm saying this because you like each other today. You should have an agreement, go to a lawyer, and he will draft you something. He will advise you what to write and how to write it, and that way your relations will be a lot better. As I said, when there is an agreement, the founders are a lot more happy. They trust each other. They come to my office and they give me a call asking about several issues, and I really help them, and they're really happy with it. But don't think that it won't happen to you. This is exactly what happens in many startups. They start with a very big smile, but they end very angry and with many tears, and they end in court, and it's a lot more expensive to quarrel about this in court. And another thing, it's a pity that a great idea was just thrown away. It's really a pity. Now, another advice that I can tell you about the founders' services and targets. For example, one of my startups, one of my clients, they decided to be very specific. For example, they decided that the CTO, they really have specific authorities, for example, selecting and handling computer servers and cloud services, smartphone application development, developing the computer software, choosing the programming languages, that the CTO, for example, will be in charge of all these things. It may be good and maybe not good. It really depends on the founders, because when you're more specific, though, it also means that if suddenly there is another thing that you didn't think of, so it suddenly may be unclear, it may be not good, and you may quarrel about it. But if you're really not specific, for example, let's say Betty will serve as the CTO of the company, and Betty undertakes to utilize her highest professional skill, diligence, ethics, and care to ensure that the services she will provide will be performed in the required professional standards. So that way you understand, okay, all the issues regarding programming, Betty will decide on them and no one else, and that way you're good to go. Now, again, it's very important when you choose your founders, choose them wisely. What I recommend, if you're not 100% sure that you're okay with your founders, reconsider it, because many startups start with some people that are a bit suspicious of each other. They don't really like each other, but they're doing it because sometimes they say, okay, he's the CTO, let's use him because I don't know how to program. He knows how to program, so he'll program the app and then we'll kick him out. I saw it once happen with one of my clients and I had to defend him. It's not a pleasant situation. You need to enter an agreement with people you trust and with people that you get along with. Go on some trial. Let's say, for example, for the first month, just work together from each one from his house or in some space that you rent for usually quite a low price. See how you work together. As I said, you don't need to sign the founders agreement the moment that you know each other. Just like a prenup agreement that you don't sign on the first date, you sign it after you propose and before you get married. Not now, it's not the time to talk about it. So try working with each other, see if you trust each other, and then when you're towards the MVP, go to a lawyer and have your agreement. That's the best advice that I can give you regarding that. But if you're not 100% sure with your founders, don't think about issues like, okay, I'll take him because he knows how to program, although I don't like him. You need to trust your partners. They will be your partners from this day on, the day you sign the founders agreement, until this business will thrive, till you'll be a gigantic corporation. Don't say it'll be okay. So I've seen many startups that the founders were suspicious of each other. Usually it didn't go well and the startup collapsed and they split and they started competing each other and it really went out bad. So I really don't recommend that. Go only with a team that you trust. That's my best advice. Don't just think, okay, we'll use each other, because it will never go on well. Although you have an agreement and it's clear, eventually it's up to you. It doesn't matter what's in the agreement. It doesn't matter which lawyer you're going to, how good is he, even if he's the best in the country. If you don't trust each other, no agreement will help you. If you don't trust each other, it won't help. You'll just quarrel and you fight and you'll argue and you won't care about the agreement. Just say, okay, I don't like him, I'll interfere with his work, I'll interrupt him, I won't trust him, and maybe I won't expose him to certain projects. And again, it's never good, it's never fine to do it. Well, basically, obviously, other things that you need to agree, maybe the name of the company. Regarding the shares, we already talked about it. What I recommend regarding choosing your lawyer, well, you need to go to a lawyer that is experienced with startups. You need to go to a lawyer that you need to ask him maybe some clients that he's giving them legal advice. Ask at least 2 clients, talk to them on phone, ask the interaction with the lawyer, not only what's good with him, but also ask some things that maybe are less good, things that he needs to pay attention to. Very important. As I said, your lawyer is very critical for your startup. As I said at the beginning, it's not just giving you the cold legal advice. He's also very involved in the startup. He has many connections. I, for example, have connections with patent attorneys, with investors, with legal consultants, with many, many people that can really help the startup, and I can use my connections to help my clients. It's very, very important. If you feel that your lawyer is not cooperating with you, there isn't good energy with him, or he just doesn't understand you, so you need to reconsider his services. This is very important to have a good vibe, also between all the founders, but also with your lawyer. He's a part of you, he's helping you, and I've already seen the difference. Some clients that came to my office after they were very unpleased with the lawyer because he just didn't understand them. You need to understand what is a startup. You need to be part of a startup to really understand how a startup thinks. That's the best thing. For example, when I want to understand what is a startup and actually how to draft a founders agreement, I really literally lived inside a startup. I was part of them. I went to them with all the meetings and appointments to really understand, because you have to understand this world in order to really help them, in order to draft a founders agreement that will be appropriate for each and every group of founders. So basically, we're done. These are the main issues of the founders agreement. There are obviously many other issues, but these are maybe topics for another lecture. I was Assaf Cohen. It was a pleasure talking to you and being here. And if you have any questions, my Facebook details are appearing here. You may always address me. Also, my email address is available to you on my Facebook page. And remember, the best and the most important thing is that you trust each other. That's the first thing that you need. After that, work with each other. And if you see that it's serious, go to a lawyer, meet someone that you really trust, and you're good to go. So I wish you the best luck. As I said, you may message me if you have any questions. I'll be delighted to answer. And that's it. It was a pleasure meeting you. I wish all of you the best luck. Have a good day.